Hello everyone, I'm Carla and welcome to our late night show Tech Talk where we discuss IT-related insight and innovations. For today's video, we will talk about answering the questions regarding the blog post entitled The Privacy Concept by Shawarma Art. So now let's move on with the video.
So, what is the article all about? The article addresses the importance of protecting personal privacy. It highlights to how an individual's privacy can be easily violated online. So, in this article, the lawsuit of Karen Hepp, a morning show host who is suing social media platforms such as Facebook, Reddit, and several other websites for using her image in inappropriate advertisement without her consent, which to this incident harmed her reputation and violated her privacy, showing how easily personal information can be misused. The article then talks about how privacy protection is involved in different areas since it is covered in law and cybersecurity. It also discussed the existing laws like the General Data Protection Regulation, which is GDPR in Europe, and the Data Privacy Act of 2012 in the Philippines, on to how these are essential for protecting data rights. So, based on the article, to better protect privacy risk more effectively, privacy by design, PBD, and privacy engineering was said to be an additional solution. So, for an overview of about privacy by design, it is an approach that embeds privacy measures directly into the creation of new systems, ensuring that privacy protection is built in from the start. That is what is said on the article. Then, privacy engineering further supports this approach by developing software that minimizes privacy risk and responsibly handles personal data. So that is why together, PBD and privacy engineering aims to prevent privacy violations and protect individuals on a larger scale.
So, privacy by design or PBD and privacy engineering are closely intertwined in their quest to safeguard personal data. PBD is a framework that embeds privacy into the core of new systems and technologies, ensuring that privacy protections are not just an afterthought. It involves principles such as data minimization, the identification, user consent, and robust security measures. By making privacy the default setting, PBD aims to mitigate risks from the outset. And also, privacy engineering operationalizes these principles by developing specific tools and techniques to implement PBD within systems and software development. This includes methods like anonymization, encryption, and user management, and continuous monitoring. Privacy engineers work collaboratively with legal, compliance, and business teams to ensure privacy is maintained throughout the data lifecycle. Together, PBD and privacy engineering create a robust framework that protects privacy at scale, fostering trust and compliance with regulatory standards.
So I am completely agree with the article that it sheds light on our crucial importance of privacy in today's digital landscape. So the case of Karen Hemp is disturbing reminder of what can we go wrong when our personal data isn't adequately protected. So her lawsuit served as a stark warning about the seriousness of consequence of privacy breaches, especially now that technology make it easy to us to capture and share and exploit our personal data without a consent. So privacy isn't just a legal matter. It's a complex issue that involves law, technology, and cybersecurity, and last the policy. Law like GDPR are vital, but they're only part of the solutions. So we need privacy engineering and privacy by design to build protections in the fabric of system design from the start. So by embedding the privacy considerations into design and development, we can better safeguard user data and reduce risk, and NIST's privacy engineering framework show us how to prioritize privacy and create a more trustworthy digital world. So for the summary of it, I agree with the article perspective that safeguarding the privacy requires a combination of policy, legislations, and technical solutions. So, like privacy by design and privacy engineering, this multifaceted approach is crucial to addressing the diverse challenge and posed by today's data-driven technologies and ensuring that individual privacy rights are respected and protected.
Cite some real life articles similar to it and compare the difference and similarities. So, one of the real life articles that is similar to the case of the Karen Heps is that the Lindsay Lohan versus the Rockstar Games in 2014. So, this article is all about the actress Lindsay Lohan filed a lawsuit against Rockstar Games, claiming that the character Lacey Jonas in the video game Grand Theft Auto 5 was based on her likeness without her permission. Lohan argued that the character's appearance, clothing, and even certain story elements were directly inspired by her public persona and image. The lawsuit was based on the right of publicity, which protects individuals from unauthorized commercial use of their names, image, or likeness. However, the case was ultimately dismissed with the court ruling that the character was a generic depiction of a young, modern woman and did not specifically resemble Lohan. This ruling underscored the difficulty of proving an authorized likeness in creative works and set a precedent for future disputes involving fictional characters and celebrity images. So basically, this article highlights two high-profile cases that illustrates how digital technology complicates privacy enforcement. Karen Hepp's case deals with the unauthorized use of surveillance images, raising privacy concerns in online advertising. In contrast, Lindsay Lohan's case focuses on the challenges of defining and protecting likeness in creative works. Together, these cases reveal the legal and ethical complexities of privacy and personal image use, prompting a need for stronger protections like privacy by design and advancement in privacy engineering. And that's all. Thank you.
The Perfect 10 versus CC Bill case and Karen Hepp's lawsuit both involve the unauthorized use of personal images and likenesses, but the way the courts applied Section 230 of the Communication Decency Act differs significantly. In the Perfect 10, the Ninth Circuit ruled that platforms like CC Bill were protected by Section 230 immunity, meaning that online platforms were not held liable for the third-party content they hosted even when that content infringed on intellectual property or right of publicity rights. The court's decision was based on the broad interpretation of Section 230, which shields service providers from liability as long as they are not directly responsible for the content in question. This set a precedent for the general rule that platforms can avoid liability for third-party content, especially they act as passive intermediaries. In contrast, the Third Circuit in the Karen Heps case adopted a narrower approach, allowing her right to publicity claim to proceed despite Section 230. The court found that Heps' claim related to the unauthorized use of her image in advertisements could bypass Section 230 immunity because it involved intellectual rights, which are exceptions under the Act.
That's all for our third Tech Talk. Thanks for watching.